Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers, with Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Good morning. Welcome to Law Power Hour. Good morning, Marla Lindeman. Thank you for coming.
Thank you for having me.
You know, it's January. It's a great time to have an employment lawyer on. She is one of the best in the state. She covers the whole state. I felt it's important for our listeners to learn about the laws of the state of Michigan as they apply to their jobs and their rights at work. Thank you for coming.
Thank you. Thank you for saying that about me. I appreciate it. I'm glad that I have the opportunity to talk to people and explain the law of employment in Michigan, because unfortunately oftentimes I get the call from people saying I've been wrongfully terminated, and I have to explain to them, no, you haven't, because the law of Michigan is at will.
I've watched her in the courtroom. She doesn't quit. She continues to battle and continues to fight the battle in the courtroom. Right to the end. I'm really respectful. I watched you, and I have great respect for what you do in the courtroom. So I wanted you to come on the show. I want you to talk about a very important topic today. We're an at-will state now.
Yes, we are an at-will state, and people don't realize that. There was a shift. People used to have what we would call, as you know, legitimate expectations in our employment. So if you worked hard and you did a good job, you stayed employed. But that's not the case anymore. The law is at will, which means you can be terminated for any reason or no reason. There are caveats, there are exceptions, and we're going to talk about those. But overall, you wear the wrong color shirt, you don't get along with your boss, and they can fire you no matter how good of an employee you are.
I call it the swinging door.
Yes.
You can enter or exit by choice. Their choice or your choice.
Yes.
And that's kind of scary, isn't it?
It's very scary because it's very almost anti-American, our system right now. The American dream is you work hard, you do a good job and you will be able to support your family. But that's not what at will is. At will is you do a great job and you still may lose your job through no fault of your own. So it's a big shift, and people need to understand it because it affects how you interact with your employer.
Wait now. I have no legitimate expectation of a continued job when I go to work on Monday morning.
Well, if you're not in a union, if you don't have a written contract, then yes, you could be fired just because you got to work on time. So you can be fired for any reason. Now, like I said, there are definitely protections under the law, and I don't want to, gloss over those. But I get a lot of calls like, I have a new boss, he just doesn't like me, she just doesn't like me, and I've been there for 15 years. I have great reviews all of the time, and now I've been fired.
Many people call my office and they ask about reviews. And they say, why do I have to go through a PIP?
Performance Improvement Plan.
And it's kind of a scary, really, and I say it's kind of a scary experience. That here I am, I'm working for 15 years on a job, and all of a sudden I get called in and say, we have a new policy, a brand new policy. And Marla, you're going to go through a PIP, and we're going to assess your work. Now, before you explain this, I want to share something with you.
Sure.
I just wrote a personnel manual for an employer.
Okay.
And one of the things that came up was the PIP, the Performance Improvement Plan. And the insurance company that insures the employer with 50 employees mandated that there be a personnel handbook and a PIP, that they have a performance improvement plan or an assessment for all employees semi-annually as part of the insurance contract.
And I want to make sure I understand that. So they have is it a performance review, or do they have to be put on a plan?
No, a performance review.
Okay.
Which could lead to a plan.
Correct.
Okay, so now the performance review, the insurance companies are requiring the performance review.
I'm divided about that because part of me as a plaintiff's attorney, someone who represents employees, thinks, you know what, that's going to be great for me because every 6 months, every year, you're writing about how great this person is. And I'm going to be able to use your words against you if I ever come to litigation. So I'm sort of surprised that they would do that. On the other hand, it does give employers the ability to write the other things, to write employment performance reviews that make someone look bad when they don't.
Okay, let's break this down for our listeners. We're in at-will state.
Right.
I said the swinging door.
Correct.
Enter, exit, as you choose. You agree with me on that, right?
That is the foundation of Michigan employment law.
I lose my job, and I call you up. How do I find you?
Well, you can go on the internet and look up employment lawyer. There's lots of legal organizations you can call that will give out recommendations. I will say that most of my business, which I'm very lucky about, is referred to me by other attorneys.
Okay, what's your telephone number if I want to call you?
My telephone number is 810-220-0600. But I am statewide. I practice in Wayne County. I practice in Oakland County, Muskegon. I'll be going to Grand Rapids in a week. So I am statewide because employment is statewide.
Well, I'm glad you said that. All of the employment laws apply statewide or on a national basis, depending on which jurisdiction you're in.
Right. And really, in Michigan, you usually want to be in federal court more often than state court. The federal laws are just more employee friendly.
Okay, now getting back to my question. So I call you on the phone and I say, I just lost my job.
Yes.
And I went through a PIP. Never been through a PIP in my life. Should I have called you before I had the PIP?
Well, I would always say you should always call if you have questions. If you don't know the answers, then you need to go somewhere and try to find answers. And with employment especially, I mean, this is something that's so important to you and your family. So you shouldn't feel scared or, worried if you pick up the phone to ask a lawyer a question. I get that all the time. Like, I'm not someone who litigates. I'm not that person. And I always want to say to them, why are you apologizing for wanting to know what your rights are? That's not something you should apologize for. That's something that you should know. That's your right to know what your rights are.
Well, thousands of workers are getting furloughed and they're getting buyout packages.
Yes.
And they don't even have the least bit of understanding of what a buyout package is and the repercussions. And that in and of itself lends itself to issues as to whether they're being fairly treated at work when they're asked to leave work.
Yes. So when there's a buyout, there are certain laws that are supposed to come into place. So they're supposed to be able to get information about other people who are being laid off, not their names, but positions and their ages, to determine if those buyouts are being made based on age.
Now I'm glad you started there. How do we get that information?
Well, there's actually a law that says that they have to do. It's called the Older Workers Benefit Protection Act, and it's attached to the Age Discrimination in Employment Act. And when there is a large scale change in the workforce for an employer, then at that point they can't just give out a buyout. They have to give out more information about who they're giving the buyout to, who they're, who they are terminating.
So if an employer is laying off 6,000 workers,
yes,
and they're giving them buyouts, a lot of people are saying, well, this is a gift. I get to leave work early. But it may not be a gift.
Well, if that's what you wanted, great. Then it's a gift. But most people, if you've been going to work, plan to go to work the next day. They didn't plan to go and end their career at that moment. They didn't get that choice. That choice was taken away from them. And there are ramifications of taking the buyouts, and it depends on what's in the buyout, of course. But people sometimes will get buyouts where if you get employment soon thereafter, you lose some of those benefits of the buyout. And it's really important that you talk to someone before you decide to go and take that buyout.
And I'm looking at the buyout in terms of the context of the wrongful termination.
Okay.
Somebody comes to Marla and says, hey, Marla, you're a great employee. You've done a great job. You've been here 27 years. I want to give you 3 years credit and a buyout. They still have to give you the package? Do they still have to provide you with all the information that they're giving?
If it's just me, if it's just one person, then then there isn't the need to do the extra information about other people who are being laid off because it's just me.
100 people that have to give you the information.
If it's that large, they're going to have to tell me so I can look at it and make sure that it is not age related.
So how would you be able to make that determination without going to a lawyer?
Well, sometimes it's really obvious when you look at the ages, but for the most part, you are going to need to go to a lawyer so that we can go and look at what's going on, what's led up to it, and really just give you the framework of what the law is. Because what happens is that the employment environment is not the same as a legal employment environment. So the way that I look at employment is going to be very different than an employee. So sometimes I have to go and say, I appreciate all that, but I need you to focus on these categories.
What do you want them to focus on?
Well, I want to know about their supervisors and the chain of command. I want to know about the people who are in the same areas of them. And I want to know about, are they being treated similarly or dissimilarly? Are there comments being made? Are there, inappropriate things going on at work? I need to know. It's so fact-based. I need to know really the whole environment But when I'm talking to them, if they think it's age, I'm like, okay, so let's just talk about age comments. Not that your boss is a jerk. Okay, we got that.
You mean somebody calls me the old man at work?
Yes, that would be something I would want to know. And it's interesting because, people think that's okay. Like, oh, we've worked together 10 years and I've always called him that. It's a joke. It's funny. No, really, it's not. But they didn't feel comfortable saying to you, please stop doing that.
Or how about the old man comes up to you and say, Marla, I really like your hair and your lipstick. Does that offend you?
That in and of itself, I don't think would offend me. But if they're saying things all the time and they're noticing how I look, and that's what they're noticing versus saying, you know what, you did a really good job on that project, or even, if you're going to comment saying, here's a teachable moment. You did this, you should do that. That's what employment should be about. You should be focusing on what I'm doing, not about how I look.
Wait a second. You said this is a great way. A teachable moment. You slipped that right in. I was listening to you. A teachable moment. In other words, if I'm helping you become a better employee by giving you suggestions about what you're doing, that's legitimate.
Correct. Absolutely. And that's helpful. I'm not saying that employers should be like saying, you suck or, but it helps everyone when you are communicating well and you're explaining what is expected in the employment environment. And I think that's a problem. And I think we're going to have that problem more and more about people not communicating as well as they used to.
And that's a big issue in the employment environment, isn't
it? It is. And there is the outside pressure and what the law requires, and they're not the same. They're not the same at all. So when you are working for an employer, you don't want to rock the boat. You want to be a team player. I mean, that's really how the work environment is today. We work in teams. There's projects. Everyone needs to come together. But the law says if you see something wrong, you need to say it. You can't just go and keep it inside. If you have a problem, if you think you're being sexually harassed, if you think that inappropriate comments are going on, if you think you have an unsafe work environment, the law requires you to be courageous and stand up and speak that out loud. And that doesn't really work in the real world often.
Okay, let's talk about each one of these separately. Let's talk about unsafe work environment first.
Okay.
How would I go up to my supervisor who's asking me to run a press and tell my supervisor that there are no handguards to protect me on the press and I don't want to operate the press without losing my job?
And that exactly is the dilemma. If I say something, I may lose my job. If I don't say something, I could lose my hand. I mean, it's a big problem. And it is, we have a situation where we don't have the protections of employees to make them feel comfortable in facing that. I remember years ago, I was asked to speak in front of a congressional hearing about medical malpractice. And I was like, why do you want an employment lawyer to talk about it? I don't do medical malpractice law. And as I was listening to the hearing and getting ready to talk, I realized why I needed to be there. Because the nurses who saw the malpractice are calling me. And they're saying, I've been asked to testify. I know that the doctor did something wrong. But if I say that, I'm going to lose my job. What should I do? And I have to explain to them, the law protects you. When you testify truthfully, they cannot terminate you. But when I say they cannot terminate you, I mean they can terminate you, but then I could bring a lawsuit and try to get your job back.
But then you're on the outside, you're fighting to get unemployment. You've got to look for another job. You may have to travel another half an hour to work or an hour to work.
If you're lucky.
Yeah,
get a
you have
job.
to make adjustments in your schedule. Who's going to watch your kids? Your shift could change. All kinds of things are going to occur. All kinds of tumults going to occur, as I call it, and change your life. So there's a big risk there.
Well, and that's what I told the committee. I said, and here's the problem. After I've given that information, that yes, the law protects you. Yes, you have the right to testify correctly and honestly. And if something happens, you can call me and I can help you. I have not ever gotten a call back. None of the people who've contacted me, as far as I'm aware, were willing to go that next step. They would rather go and protect the doctor and protect their job than lose it. And that's the dilemma we're facing.
And you have the same dilemma when you're working in a production job.
Correct.
If you make a complaint, the supervisor is going to find somebody else to replace you, especially if they use one of these labor brokers and they're contracting and bringing people in, because the labor broker is going to have the responsibility if you get injured at work. So what do you do?
In the end, again, with a labor broker, I can still go and protect the employee by suing not just the labor broker, but the employer who says, I don't want them here because they're complaining. I can bring them in as joint employers. The law gives me the ability to help them, but it's not fast. I can't require them to keep you employed.
And while that's going on, how am I going to survive? What am I supposed to do? Get unemployment or go look for another job?
Well, you have to do both. The law requires you to mitigate your damages. Just like the law requires you to speak out, if you are terminated, the law says you can't sit at home. You need to try to get employment. You need to try to get another job. You don't have to go from, being a high-level manager to working at a fast food place. But you have to try to get a similar job in a similar location. You can also, though, the law also will allow you to go back and get education to make yourself more marketable. That also would be considered appropriate mitigation. So, and that's what you should do. I mean, I always tell people when they call me, it's better to have a good life than a good lawsuit. If you get terminated and within 2 weeks you get another job, great. Maybe I can't bring a lawsuit on your behalf anymore because you've mitigated your damages and life has gone on for you. But that's a great result in my mind, because it is better to have a good life than a good lawsuit.
We read about all these employment discrimination lawsuits with these big verdicts in the newspaper. An employment discrimination lawsuit is not a lottery ticket, is it?
It is absolutely not a lottery ticket.
And I mentioned it for that reason, because it's not easy to handle an employment discrimination lawsuit. You've handled both sides of those, haven't you?
Right. So I've been lucky in my career to represent, I represent mostly employees. I have represented some employers over a decade at this point. Every once in a while you hear about this big case, but the reason you hear about it is because it's news. It's not happening every day. As a matter of fact, 95% or more of all employment cases, as most litigations are settled before trial. So most cases are not going to trial. So you're really not hearing about the reality of litigation when you read something in the paper. When you're reading something in the paper, something different is happening in that suit. Either the lawyer really wants publicity, or it's an unusual result.
So it's a shocking case more than
correct.
Common everyday occurrence.
Correct. In most of those cases, if you follow up years later, if there's been a huge verdict, has been dramatically reduced by the Court of Appeals or Supreme Court to a different level. So you read it, and then, $25 million. And then 5 years later, that $25 million was really, cut into a couple $1 million, which is still a lot of money. I'm not saying it isn't. But you don't hear that side of the story usually. It doesn't get covered because something else is more exciting.
Okay, let's get into the real world of an employment discrimination or at-will case.
Sure.
It's an at-will employment. I'm terminated. I come to you and I say, wait a second. They let me go because I was there too long. I'm 65 years old. He said, it's time for me to retire.
Okay.
What rights do I have?
Well, if someone literally told you that, then you have, first of all, a very good case. It's something we call a direct evidence case, which means you've been directly told that you are the victim of discrimination.
Okay.
So at that point, I would be saying to them, we need to get your personnel file. That's always the first step. Always the first step is for me to get the personnel file. And we can talk a little bit about that in a second.
How do you get a personnel file?
So there is a law in Michigan. It's the Bullard-Plewicki Act, but most people know it as the Right to Know law. And what the law says, and most people don't understand the law.
Now, those of you who are out there listening, you can get a copy of your personnel file anytime. Is that correct?
Yes, but this is what people don't understand, even attorneys. Under the law, you have to request to see your personnel file first. Once you ask to see it, then you get a right to get a copy of it. So oftentimes you'll have lawyers who will just send in this boilerplate, I want the personnel file. And sometimes they'll get the personnel file, sometimes they won't. But later on in litigation, all of a sudden, new things that weren't in the personnel file show up. Now, if they had done it correctly, if they had asked to see it first and then got the copy, there's a part of the law that says you can't do that. When we ask you for the file, you can't later on go and put new things in there. You can't do that. But if you don't do it correctly, then you open it up to the employer being able to pad the personnel file.
Okay, so I go into my employer and I say to my employer, I'd like to look at my file.
Yes.
My employer says, you can't look at your file. And I say, well, I'm entitled to. And I bring a letter from the lawyer saying, under the Bullard-Plewicki Act, I'm entitled to look at my file. If you don't let me look at my file, can I sue you?
Yes. You can sue, and the stick of that law is that you would have to pay my attorney fees. If I win, then the employer will have to pay the attorney fees of the person who's suing, and that can be a lot of money. Litigation is expensive, unfortunately.
Okay, so we do this. So I go in and look at my file. I don't know what I'm looking at.
Correct.
It's confusing to me. The one thing I know that is I filed an application for employment, and at the bottom of it, it says that I'm an at-will employee. So I go back to my lawyer and say, well, they had a right to get rid of me because I'm an at-will employee. Do you still want to see my file?
Absolutely. And before that, I want to step back because I think it's important people know this. When you see your personnel file, I tell people number the pages. Number the pages. If there's something on the front, if there's something on the back, number them. Because we want to make sure that nothing ever gets added in later on.
Wait a second now. So I take my pen out.
Yes.
And I go in, and I'm sitting there, and the personnel director says, hold on, you can't do that.
Yes, you can.
Why? What gives me the right to do that?
Well, the law does. I mean, there's certain things that the right to know law allows you to do. For example, you see something in your personnel file, and you've never seen it before, or you disagree with it, you have a right to put a rebuttal into that file. You have a right, and your employer must put it in. So I've never, and I've been doing this almost 25 years now, I've never had any employer ever have a problem with doing the numbers.
Okay. You brought up an interesting point. I go in there and I put down page numbers, and I request a copy of it.
Yes. You
want to review that with me, don't you?
Absolutely. So what I'm looking for are certain things. One, years ago there was an insurance case. It wasn't even an employment case, an insurance case that started with in the contract, it limited the statute of limitations, which is the amount of time you have to sue in a contract. And from that case, which allowed a contract to go and reduce something that the legislature gave you, the amount of time the legislature gave you, can be changed by a contract. Employers started doing this.
Chrysler Corporation does it regularly, 6-month statute of limitations, right?
Yes, 180 days, and Chrysler is very well known for that. There's a lot of case law about it. Now, so I'm looking for that because I need to know how long we have to sue, especially because the 180 days is a problem under federal law. Now, thankfully, federal law often does not allow you to shorten the statute of limitations because, for example, the Equal Employment Opportunity Commission, the EEOC, has jurisdiction to review a claim for 180 days. So if you have that, you have to sue within 180 days, and they have 180 days before you can sue. That's a conflict. So often under federal laws, employers cannot do it, but under state laws, under Michigan's Elliott Larson Civil Rights Act, under the Persons with Disabilities Civil Rights Act, Whistleblowing Protection Act, which already is 90 days, so doesn't usually come into play, you can limit the amount of time. So I need to know how quickly I need to act. So that's the first thing I'm going to be looking at. Also, employers are sometimes requiring employees in their application to waive the right to a jury. So I'm looking for that. I'm looking to see if they've required you to go to arbitration. So we're not even in the court system. These are all things.
Can an employer do that as a condition of employment?
Yes. And
can my employer say to me, if you want to work here, you can't go to court and you have to arbitrate your case?
Yes, absolutely. There's federal and state statutes that make that legal. But people don't even know. You sign your application, no one reads the fine print. They just don't. So that's what I'm looking for, to see what you've signed. And even non-competes. I get people calling me up saying, I've been working for an employer for 12 years. Now they want me to sign a non-compete agreement, but they're not giving me any money. So, that can't be legal, right? They have to give me something. There has to be some consideration. And the courts have said that the fact that they allow you to work the next day is enough consideration. So if you don't sign that non-compete, then you may not be employed the next day.
Well, in terms of a non-compete clause, when you hire, normally there would be a provision that to be a non-compete clause in the hiring agreement.
Yes, unless the employer later on decides that they want it.
And if the employer decides they want it, they have a right to get it.
Yes. And, the law does have some protection. It has to be limited in time, but up to 2 years is often acceptable. It has to be limited in geographical scope. So, if the employer is only in Detroit, they can't keep you from working in Southfield, for example.
Okay. Now, don't slug me, but we're going to get to the next step here.
I would never.
You review my file.
Yes.
Everything's in order. And I tell you that they let me go because of my age. Do you start a lawsuit or do you write a letter to the employer?
Well, I'm still going to be asking more questions because I really want to know, as an employment lawyer, I step into your shoes. And I wasn't there when it all happened to you. I explained to people that in a car accident, it's a moment in time. We're all talking about what happened in that crash. In employment, we could be talking about 6 months to a year or even more. So I'm going to spend quite a bit of time trying to understand about that. But once we get to the question about litigation, I often do tell my clients that we should talk about trying to negotiate beforehand. One, if we're in the EEOC and they're reviewing it for 180 days, they're going to go and push mediation anyways. So
what's mediation?
Mediation is a formal process versus what we're talking about. Me writing a letter is an informal process where you actually go to the EEOC They'll have a mediator, someone who's trained in helping to resolve conflicts between employers and employees, and they'll try to come up with a settlement, something where both parties are in agreement that this case doesn't need to be litigated, that there has been a resolution. So the employer says, we'll give you, $20,000 to go away, basically. Something like that. And could be more, it could be less. They could say, we're not going to give you anything. But it's also a good way to find out what the employer's arguments are sometimes.
Okay, but I'm saying it's all age, because I'm just too old for the job. They say that they've got younger people that can do the job faster than I can do it.
And if we are lucky enough that they're that stupid to admit under oath that that's the reason they told you, that that's the reason they fired you, then great, because we just won that case. But that doesn't happen. They will come up with something else. They will always come up with something else.
Well, one of the things that I see happening is that they claim with older people, and correct me if I'm wrong, that they changed the job description and they claim they have new technology. And because of the new technology, I haven't been trained. Therefore, I should retire. Do they have a duty to train me? I told you you're going to punch me.
No, definitely, I'm a non-violent person, so that will never happen. Employers have flexibility. So this is going to be one of those close calls. If the reason that they're doing it is because they want to push you out, then that's illegal. But I actually had a case where the person, it wasn't an age case, it was a disability case. And my client was going from one position to another position, and they refused to train her. They trained everyone else, but they did not provide her with the same training. And they started saying, you're not meeting expectations. But, when I actually went to court and we were doing depositions, they admitted they didn't give her enough work to meet expectations. So if it's just a matter of training, it could be a problem. If it's the fact that you are being treated differently than everyone else, if they're making the situation to try to hide their age discrimination, then they're going to be in trouble.
Okay. I think we should take a break for a minute. I've been pushing you and pushing you and pushing you. Let you catch your breath, and then we'll be back. Okay?
Yes, thanks.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers. With Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident, where are your records? Flood damage. Where are your records? Fire damage. Where are your records? With a loved one in the emergency room, where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
So the FMLA laws in this country apply to employers who have more than 50 employees, correct?
More than 50 employees, and then you also have to, within a 75-mile radius, which is important because, you know, you may have someone who has 25 here in Southfield and 25 in Detroit, and you put them together and there's 50.
So it's a cumulative number
Yes.
from all of your locations.
Within 75 miles.
Right. So then you have to have an FMLA policy in place, correct?
Yes, the law requires that if you are, if the FMLA applies to employer, you have to have a policy about it.
You know, I have found the FMLA laws to be the most confusing laws. And believe me, it's harder to read FMLA laws than it is to follow a recipe and make a cake from scratch. I'm sorry. I mean, it's very, very difficult. The counting is one of the issues. Does every week that I miss on an intermittent basis count towards the 12 weeks?
Yes. So first you have to be an eligible employee, right? So you've had to have worked for at least a year, and you had to have at least worked 1,250 hours during that year. So that's basically about 25 to 30 hours per week. So you can be protected by the FMLA even if you're a part-time employee. So if you're eligible and then you have something happen that's an eligible FMLA reason, and I'll talk about that in a second, I don't care if you're out for a car accident, for a work-related injury, whether you're on sick leave, it's always counting towards your FMLA. Pregnancy leave, yes, definitely under the FMLA. Now, again, you know, you have to have at least 50 employees. In Michigan, if you have less than 50 employees, you have no right to a pregnancy leave. None. So
50 employees, it could be cumulative, it could be like a dentist who had 3 offices, it'd take the sum total from all of his offices, would make 50 employees.
yes.
Okay. So you have to have a handbook, you have to have policies, and you have to set forth all the parameters for the FMLA.
Right. And really, that's the easy part, because one thing that the FMLA Code of Federal Regulation does well is there's forms that you can use. There's language that you can just cut and paste and put into your personnel file, personnel policies. So very often you're going to see the same exact language in everyone's policies. So
Okay, so we get through this process. So I get hurt at work.
okay,
And instead of paying me workers' compensation, and this happens more often than not,
okay,
and if you're out there and it's happened to you, you better call in here because you have to learn how to protect yourself. So I'm off 12 weeks. I haven't been paid workers' compensation. I've got to go see a lawyer about workers' compensation, and then I get fired by my employer, and then I can't collect unemployment because I'm claiming I'm disabled and I can't work.
Yes.
What am I going to do?
That's what we call the Bermuda Triangle of law, where all these different laws come together and sort of a big abyss. So under the FMLA, you only get 12 weeks, whether it's intermittent, like we were talking about, or if it's at one point. After 12 weeks, the FMLA no longer protects you. There is a buffer with the ADA. If it's going to be another week, 2 weeks, maybe even a month, the employer may need to accommodate you. But after that time, they do have the right. If you cannot work, they do have the right to terminate you. And if you...
It's not fair. That's what my clients tell me. It's not fair. I got hurt on their job. They're not paying me workers' compensation. I'm still disabled. The doctor won't let me go back to work. It's not fair. How can you help me?
As an employment lawyer, I'm going to be saying I'm going to have to work with a workers' compensation attorney. And I'm going to have to look really at this employer. What have they done in the past? How have they treated this? Have people with other disabilities been given more leeway? If that's the case, under workers' compensation law, there's actually illegal retaliation. Like if they were terminated because they got injured.
Okay, so under workers' comp, there's a special provision for retaliating against employees because of work-related injuries.
Right. And this is actually sort of interesting because workers' compensation cases are not in court. They're in an administrative law area. So the retaliation case, though, is in the judiciary, in court. So I always have to work hand in hand with the workers' comp attorney to make sure that we're working together in the different forums.
Okay, so given this scenario, what do you do? How do you handle this situation under family medical leave? What's your best advice to a person?
My first best advice is remember that your doctor's not a lawyer. Oftentimes, like I get people calling me and saying, well, my doctor says, and I'm like, would you come to me for a cancer diagnosis? No, of course not. Your doctor is well-meaning, but they did not go to school for this, and the law is ever-changing. So that's my first and foremost. Second is, if you see the writing on the wall, you need to call attorneys from the beginning, because we need to start protecting you before you got terminated. We need to be making sure that you have asserted your rights, that you have done everything correctly, that you have put your notice in correctly, that you have all your facts. Knowledge is power.
So if I get hurt at work and I'm off and I can go back to work with restrictions, I'm further ahead by going in and asking my employer to accommodate me and find a job for me, because that sets up a whole new channel.
Correct.
I call it a channel, a whole new opportunity if they don't accommodate me, correct?
Correct. But those accommodations, you need to ask for them in writing. Under Michigan law, there's a requirement that you put it in writing within 180 days, and it's questionable whether a doctor's note is enough. So even though your doctor gives you a note, you should put it in writing yourself, saying, I am requesting these accommodations, or I'm requesting that we start the process to determine the accommodations.
Okay, so I get hurt. It's week 4, hurt my back. I'm limited. I can't stand 8 hours a day. I need a chair. So I write a letter, bring it into the personnel office, say, I'd like an accommodation. I can come back to work. Do you have a job for me with a chair? Is that good enough?
That should be good enough. That should at least start the process. And it is supposed to be a process. It's supposed to be a conversation back and forth. The employer does have some rights to go and get perhaps a second opinion or a joint third opinion. But yes, it's very helpful if you can say, this is what I need, this is what I'm asking for. And the law really does require reasonable accommodations. If you're just asking for a chair in a job that you can sit in and they don't do it, that's going to be a pretty open and closed case.
Okay, but suppose the employer waits 12 weeks before they send me to the doctor to make a determination. So the family medical leave's over and they terminate me. Then they send me to the doctor, and the doctor says, well, they can work with restrictions. Where am I? I'm in the Bermuda Triangle at this point.
Well, and that's what I'm saying is that you need to get your ducks in a row sooner rather than later. In that situation, though, it's sort of, it could go either way. One, you should be seeing your own doctor at that point, so you don't need to wait for their doctor. But
28 days to see your own doctor under the Michigan law.
Under workers' comp.
Right.
Under workers' comp, yes. But you may still see another doctor. Like if you have your general practitioner and for example, I have allergies, so I'm going to go and see my allergy doctor right now every week because I take my shots. Even if I got injured on my job, I would still be doing that. Like they can't. So there's still the ability to see doctors. So I would be suggesting that. You're going to have to pay for it. Workers' comp's not going to pay for it, but that may be something to do to protect you. But still, 28 days is 4 weeks. It's not 12 weeks. So you still have the ability to start that process. So sooner rather than later. But if it turns out that you can come back to work with accommodations and it's really close in time to your FMLA time, that's when the ADA is going to, the Americans with Disabilities Act, is going to be your friend. Because there is case law where you have to extend that time period if it's just a little bit, if it's not really going to put you out, if it's reasonable, and work with that person. So the way I explain it is that the ADA gives you a little bit of a buffer to the FMLA. Now, you notice I don't talk too much about Michigan's laws because, and I haven't done the research in a long time, but the ADA was amended to make it much more broad. Something like 98% of all ADA cases were being dismissed by judges and juries because it was impossible, almost impossible, to be disabled under these laws. The federal law got changed to be more inclusive. Our state law did not.
No, our state law is if your disability is directly related to your ability to perform the job, you're out of luck.
It's not quite that cut and dry, but yes, it's very hard. I can't even remember the last time I brought a state case that was in state court under the Persons with Disabilities Civil Rights Act.
It's absolutely wrong to bring a case in state court because of that.
Correct. Yes. If you have no other choice, because of the statute of limitation issue, then perhaps you have to do that. But for the most part, I'm always going to go under the ADA, and I'll include a Persons with Disabilities Civil Rights Act claim, but I'm going to be in federal court. So.
Okay. Now, I want people to call you if they have a problem. Tell me how they can call you.
They can call me just by picking up the phone. My phone number is 810-220-0600. I'm also available via email, lindermanlaw, LINDERMANLAW, at sbcglobal.net. SBC stands for Southern Bell Company. I find that interesting. People don't know what it stands for.
Okay.
So lindermanlaw at sbcglobal.net. That's usually actually the best way to get a hold of me because I'm often in court, on the road, meeting clients. I'm very lucky to be that way.
Well, that's wonderful. But if somebody wants to get a hold of you, they've got these two vehicles to reach you.
Yes.
And if they've got a question, they should, if they're reaching you by email, they should be in a position to scan and send information along.
Yes.
So that you have a better understanding. I always tell people when they want to reach me by email, scan your document, send them to me, give me something that I can look at. So when we have a conversation, we can have a reasonable conversation.
Yes, but please do it in a minimal amount of emails. Sometimes I get like 20 or 30 emails from someone, and I'm like, I'm going to miss something. You need to go and put it together in a way that I can really review it.
Well, I want you to call Marla if you have a problem. And I know we didn't have anybody call in today, but fortunately this show is repeated several times during the week. And those people who have problems, call Marla, because she does not back down from a fight. She's more likely than not to position herself, not to take the hit, but to make it. Thanks for coming, Marla.
Thank you. Thank you so much for
You're
having
welcome.
me.
I want you to come back again.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers, with Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?